Order. In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. I'm pleased to stand and speak about a very important part of our trade agreements that are going on in our country right now. Many Canadians are concerned about the foreign investment protection agreements and trade agreements that this government signs and is currently negotiating. And one of the main areas of concern in these agreements relate to what are known as investor-state dispute mechanisms. Now, Canada has 21 FIPAs in force with countries as far afield as Russia and Argentina, Thailand and Romania. Many more are awaiting ratification or are currently being negotiated. The FIPA model has been enshrined in the North American Free Trade Agreement. Now, Mr. Speaker, the NDP believes in setting up a rules-based system that protects investment while preserving public policy flexibility, democratic decision-making, and the rule of law. But ISDSs, as they are typically written, do not conform to principles of the rule of law. People point out that these mechanisms provide no security of tenure for arbitrators. There's a lack of an effective appeal procedure. It is rife with conflicts of interest, and they are not necessary where the state parties have matured judiciaries where investors can bring their complaints and have those complaints adjusted according to the rule of law. Now, the China-Canada FIPA that is currently before this Canadian Conservative Cabinet even allows for arbitration to happen in secret. Now, that's unprecedented in Canadian treaties, and it's a major step backwards. Many people question investor-state in general. Criticism comes from across the political spectrum. Australia has decided not to pursue investor-state provisions in trade and investment agreements. So has India, South Korea, and South Africa. Now, even those who are generally supportive of free trade agreements are worrying about the implications of investor-state provisions. Lawrence Herman, counsel to Castles Brock and Blackwell, and a senior fellow of the C.D. Howe Institute, someone with long experience in international trade and international business transactions, has said this: a repeated criticism of the FIPAs is that they grant foreign investors greater rights than those available to local companies under domestic law. This may not have been a concern when Canada was a capital exporter, but now that things have changed, how do we feel about this? He says regarding NAFTA claims, it is a fact that many more claims have been filed against Canada than against either the U.S. or Mexico. Canada seems to have become the target of choice for U.S. investors, not Mexico, as had been expected. Mr. Herman points out a concern he has that these arbitration decisions are rendered by ad hoc tribunals appointed for a given dispute only. The members are drawn from a variety of places around the globe and have different backgrounds. Yet these impermanent tribunals are often deciding issues of social or economic policy of national importance with no security of tenure. He points out that businesses are concerned about sovereign risks in other countries, and following Australia's lead, that Australia has decided that businesses should make their own assessments about whether they want to invest in those places. He says that the problem is that Canada has proceeded down the FIPA path for years without a critical look at how these agreements really help us, both abroad and at home. Civil society is weighing in. Recent transatlantic statements signed by dozens of European, Canadian, and Quebec organizations strongly oppose the inclusion of an excessive investment protection chapter and IS dispute settlement process. They point out that such provisions weaken democracy, that in terms of the CETA agreement currently being negotiated, that Europe and Canada both have legal systems that are more than capable of handling disputes between investors and governments, that ISDS forces taxpayers to pay for the public health, environmental, and other regulation of their governments to foreign corporations if they're sued. They say that there is an inherent bias in the system, and it's prone to corporate bias. There's also scant evidence that these mechanisms encourage inward or outward investment. So, Mr. Speaker, what I want to ask the government is, why are they pursuing an investor-state provision in these agreements when it subjects Canadian taxpayers to potentially billions of dollars of lawsuits? Can't they construct a protection for investment that preserves democratically elected government's ability to make policies for the economic, environmental, and social development of the Canadian public?
Hear, hear.
Why can't we do that?
The Honourable Parliamentary Secretary to the Minister of International Trade.
Thank you, Mr. Speaker. And excuse me. And of course, Mr. Speaker, there's nothing in the FIPA or any of the free trade agreements that prevents Canadians, federal government, provincial governments, and municipalities from making economic, social, or environmental policy to suit themselves. And quite frankly, Mr. Speaker, I hardly know where I've responded to this member so many times on this subject, and it's pretty hard to combat rumors and innuendos and half-truths and misleading statements, and it's fairly difficult. Great example. Folks, the honourable member said himself, folks generally supportive of free trade. What's that? What's that mean? Like, that's great, some kind of half-legalese speak craziness that no one really knows who are those people? Claims against Canada. You're going to hear this time and time again. I've heard it. I've heard it from the NDP party. Claims against Canada by the United States or by Mexico. Well, how many claims have been against Canada? You won't hear that number. And I'll tell you the other number you won't hear, Mr. Speaker, is how many have been successful. That's another number you won't hear. So, listen, we're a trading nation. We're a trading nation that needs clear, solid, unequivocal rules to trade by. Part of that, is negotiating free trade agreements around the world. Part of that will be the final stages of the very CETA, the Comprehensive Economic Trade Agreement with the European Union that the honourable member discussed. He discusses some of the perhaps challenges in a negotiation that's not completed yet, but what he doesn't say is that expected to be a 20% increase in Canadian trade, expected to bring $12 billion to the Canadian economy. And in order to do that, we do need clear parameters on investment, and we do need surety for Canadian investors abroad and foreign investors in Canada. Let's take a look at the fear-mongering and the record, Mr. Speaker, of the NDP, and let's talk about protection against discrimination in the marketplace and how you do that. I'll tell you how you do that. You do that with foreign investment promotion and protection agreements. That's how you do it. You do that with investor-state provisions. That's how you do it. There's no guesswork. There's no tying it up in courts for years and years and years at a time. There's an arbitration process, and the issue is settled. The former NDP critic from Windsor West said he supports the efforts of big union bosses to stop any future trade negotiations with Korea, Japan, and the European Union because apparently it affects somebody or someone who are NDP supporters. Former NDP trade critic from Dartmouth Cole Harbour described the free trade agreements as, quote, job-destroying. Another former trade critic, member for Burnaby New Westminster, said the free trade has, quote, cost Canadians dearly. Explain that. Let's have a reasonable, rational debate about this, and hopefully let's have it soon. But let's not speak in innuendo and rumour and half-truths.
The honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. Well, here's some facts for the honourable member. The number of investment arbitration cases has surged in the last 2 decades from 38 cases filed in 1996 to 450 known investor state cases in 2011. Ontario has just been sued by an international company over its decision to try to generate a local wind farm technology sector. Quebec has just been sued over its decision to put a moratorium on fracking in its province. Newfoundland was sued successfully by Mobil when they tried to just have that company invest R&D in their province. And these are examples where Canadian taxpayers are on the hook for hundreds of millions, if not billions of dollars. Those are facts and realities. Now, the honourable member can only babble and gaffe on about generalities and name-calling. He can't seem to to respond directly to the issue before us, which is why is this government putting investor-state provisions in agreements that subject taxpayers to damages for their government simply making policy in the interest of Canadians? Answer that direct question.
The Honourable Parliamentary Secretary.
The question's still not been answered, Mr. Speaker. 350 cases brought against Canada. How many have been successful? You know, the Mobil Oil case in Newfoundland, you know, surely the honourable member doesn't think that's a proper example. You know, Mobil Oil the Newfoundland government had 4% of the shares in Mobil. That prevented them from having a seat on the board. They wanted 5%. That would have given them a seat on the board. I can understand the government of Newfoundland wanting that. However, you cannot change a written agreement in this country without both parties agreeing to it. Therefore, arbitrary action on behalf of one party, whether that's for the good of that party or not is yet to be decided, has to be agreed to by both sides. What happened in the case of Newfoundland, Mr. Speaker, it wasn't agreed to. It went to court. Newfoundland got their seat, and they also lost their case.
La prochaine.